Meeting to order. I call the meeting to order. Today we are here to study the subject matter of Part 5, Division 23 of Bill C-19, an act to implement certain provisions of the budget tabled in Parliament on April 7, 2022 and other mayors. And I would like to welcome our witnesses from the Department of Citizenship and Immigration for appearing before the committee today. We are joined by Julie Cheze, Director General Financial Strategy, Philippe Somogwari, Director General Strategic Policy and Planning, Marcel Poyer, Director Fees and Activity-Based Costing Division, Jonathan Josie Kopp, Acting Director Express Entry Policy. Thank you for appearing before the committee. You will have 5 minutes for your opening remarks, and then we will go to a round of questioning. So you can please begin. You will have 5 minutes. Thank you.
Thank you, Chair. Good afternoon, and thank you for the opportunity to discuss the proposed changes to the Immigration and Refugee Protection Act that are included in the Budget Implementation Act. My name is Philippe Somogwari, and I'm Director General of Strategic Policy and Planning at Immigration, Refugees and Citizenship Canada. I'm joined today by my colleagues, Julie Cheze, Director General Financial Strategy, Marcel Poirier, Director Fees and Activity-Based Costing, and Jonathan Joshi Koop, Acting Director of Express Entry. The proposed amendments cover two areas. The first are changes to Express Entry, and second are an exemption from the Service Fees Act for certain fees established under the authority of the Immigration and Refugee Protection Act. Express Entry is the application management system for a number of Canada's economic immigration programs. Candidates express an interest to immigrate to Canada, and if they meet the basic requirements of one of the programs managed by Express Entry, they are placed in a pool of pre-qualified candidates and ranked against one another based on a transparent scoring grid that favors individuals with high human capital. IRCC then invites the top-ranked candidates in the pool to apply for permanent residence through one of the programs through regularly held invitation rounds. The proposed amendments being sought through Division 23 of the Budget Implementation Act will build upon Express Entry's existing flexibilities and support Canada's economic recovery and future growth by permitting the department to more easily select candidates that meet a range of economic needs and priorities. More specifically, the amendments authorize the Minister of Citizenship and Immigration to invite foreign nationals to apply for permanent residence through Express Entry on a new basis. The eligibility to be members of a category that would support an economic goal identified by the Minister. Eligibility requirements to be a member of a category would be established by the Minister and could be based on factors such as work experience, educational background, or language skills. For example, if there was a desire to leverage immigration to support the growth of Canada's tech sector, a category of Express Entry candidates would be created based on criteria such as their possession of work experience in their sector occupation and or their possession of a related educational credential. Invitations could then be issued to the top-ranked candidates in that category. The Minister would establish the category through ministerial instructions and post details, including the eligibility criteria, on the departmental website. To support program integrity, the proposed amendments also direct officers to refuse applications from candidates who cannot demonstrate they were eligible to be a member of the particular category. To support transparency around these authorities, the proposed amendments also require the Minister to identify the economic goal they are seeking to support in establishing each category. The amendments also include the requirement for the Minister to report on the use of these authorities through the annual report to Parliament on immigration. Amendments in Division 23 also include technical amendments to Division .1 of IRPA, notably elimination of a minor inconsistency between English and French versions of Division .1, and to clarify the Minister's authority to specify to which program an invited applicant may apply to in the event they qualify for more than one program. With respect to amendments regarding fees, the Department is seeking an exemption from the Service Fees Act for 4 fees established under the authority of the Immigration and Refugee Protection Act. They are the authorization to return to Canada, rehabilitation for criminality and serious criminality, restoration of temporary resident status, and temporary resident permits. The Service Fees Act received assent in June 2017 and requires that service standards be established for all fees and that fees be remitted to clients when these services standards are not met. Services related to these 4 fees exist to address an inadmissibility for applicants that may have a criminal record or have been flagged to have special circumstances that prevent them from following the regular temporary residence pathways to enter Canada. As such, these services have highly variable processing times that are dependent on clients' individual circumstances, and therefore an exemption from the Service Fees Act is being proposed as it's difficult to establish reasonable and meaningful service standards for these fees. Thank you for the opportunity to provide you with more information on these proposed amendments, and I look forward to your questions.
Thank you. We will now proceed to our round of questioning, and we will begin with Mr. Janis. Mr. Janis, you will have 6 minutes. You can please begin.
Well, thank you very much. Thanks for being here. Sorry, just shuffling my notes here. So one of the changes that's been brought in is with respect to fees collected. Could you just explain more precisely what the impact of changing of the Service Fees Act changes would be?
I can answer that, Madam Chair. So, in terms of the changes specifically, it will not change the value, the
Sorry,
value of.
Can you put your mic down, please?
Sorry for that. Yes. So, in terms of changes to these fees, so it will not change the Service Fee Act itself. What it will do is these 4 fees will be exempted from having to set service standards for these 4 fees that are related to an inadmissibility.
Right. So what is the specific effect? So you're not eliminating the fees in those categories, but you're eliminating the requirement that service standards be associated with those fees.
Correct.
And why?
This is exactly it.
Why is that? Why is that change being made?
Because technically this is extremely difficult to establish service standards for these fees because it can run from 2 days to 1,200 days. So we would be in a position where we would have to remit, if we do not meet the service standards, we would have to refund these fees to applicants, where it's extremely difficult to establish predictable and transparent processing times that will apply to a large number of these applications. It's basically more of a case-by-case basis for these types of applications.
Okay. I'm going to try not to sound like my 4-year-old here, but again, why? Why is it hard to establish consistent processing times and service standards for these 4 particular categories of application? I mean, it does seem like we're struggling to meet service standards across a very broad range of applications, but why is it particularly difficult for these 4 in a way that you think justifies their exemption?
I think the question right now is not really meeting the service fees as of now because it's extremely difficult to establish any. So I think it's not really a question of meeting them, but it's a question of establishing something that is predictable and to what we can abide for, because as I was saying previously, in certain circumstances, an application can take months to go through criminal records to ensure that the person can enter Canada and can be admitted to Canada. So it's really dependent on every applicant's individual situation in terms of their criminal record or their situation.
Okay, so that the reference to criminal record I understand that to be a reference to one of the areas of exemption, which is determination of rehabilitation, and intuitively, I would understand why that might be one where it is more difficult to establish service standards. But another one that's being exempted, for instance, is an application for a temporary resident permit. So as a result of these changes, someone applying for a temporary resident permit no longer would have the benefit of having an established service standard. It doesn't seem like assessing an application for a temporary resident permit should be the sort of thing that is any more or less difficult compared to many other application categories to establish what an appropriate service standard should be. So I'll accept the I can accept the inclusion of the one on determination of rehabilitation, but explain to me why a temporary resident permit is something where somehow it's difficult to establish what a service standard should be.
In terms of this application specifically as well, temporary resident permits, although again not specifically related to criminality, is also highly dependent on an individual situation in terms of being able to become admissible to enter the country. So,
sorry, isn't that true of all categories though? Like how is that particularly true of an application for a temporary resident permit any more than it's true of an application for that a spousal application or an application for citizenship or an application for a refugee or how is that uniquely difficult compared to or uniquely individualized compared to the other categories?
In terms of specifically this, again, I think all our other, like for example, visa applications, we can put in predictable service standards and processing times and calculate how we meet them. In terms of a temporary resident permit, because it's highly dependent on an individual situation and their ability to provide the information that is required. Sorry,
I'm running out of time. But again, of course, in the case of a temporary resident permit, it's highly dependent on the individual situation. But the same is also true for a refugee application, and I would, in some ways, it might be even more difficult in that case because you're talking about information that you need to gather from abroad compared to. So, I mean, I guess I'm out of time. I still don't understand the rationale for why these categories would be exempt from the service standards that we expect in other cases, and especially at a time when we're failing to meet service standards in so many different areas. Why the government would be seeking exemptions from those standards in these cases. So, I don't know. Do I have 20 seconds? Oh, okay. I guess if you want to respond to that in the time you have, and I'll go for it.
I don't think I have much more to bring in terms of details on this, but I understand your point of view. The Service Fees Act applies to a number of fees in the government. Other fees that were set by the department are not subject to the Service Fees Act neither, and we do have service standards for these fees. So although they're not subject to the Service Fees Act, for example, a temporary resident applicant
sorry
visa.
for interrupting. Time is up for Mr. Janice. We will now proceed to Ms. Lalonde. Ms. Lalonde, you will have 6 minutes. You can please begin.
Merci beaucoup, Madame la Présidente.
Thank you very much, Madam Chair. I would like to thank our witnesses for having joined us so quickly.
Into my questions, I understand that C-19 aims to make enhancement to the Express Entry program for highly skilled individuals who want to immigrate to Canada. Could you briefly summarize these enhancements, please?
Yes, thank you, Chair. I would be happy to. The amendments to the express entry provisions in the Act essentially provide the ability for the Minister to issue instructions that would focus on particular candidate attributes in the express entry pool and allow for invitation rounds to focus on individuals with those particular attributes. The current formulation of the Act specifies that the Minister can issue invitations based on the total size of the invitation round and based on the underlying regulatory program upon which the candidate qualifies under. So this would provide flexibility to, for example, be able to invite from candidates from the express entry pool that have a particular work experience or credential, or who, for instance, are French speakers destined to an official language minority community. So these are currently features that are not permitted under the current formulation of the Act. Thank you.
Thank you very much. So you did, give some example. I'm going to ask the why, and I think if I could say, you could just explain why is the government proposing these change now?
Yes, thank you, Chair, for the question. The pandemic in particular really highlighted why the government, the value of the government and the immigration program being able to invite those who wish to come to Canada to participate in the labor market, whether they be in essential services or are in areas of the economy where labor is needed. And as such, and this I would add, was something that we were striving to do prior to the pandemic. But I think the pandemic placed a focus on the need for our economic immigration programs to be as flexible and nimble as possible to address what could be labor market shortages, sectorally, nationally, or regionally, and also be able to meet other economic goals. Whether they be defined by the government through, speeches from the throne, through the budget, or that are in fact contained within the objectives of the Immigration Refugee Protection Act itself. Thank you.
Thank you again. And through the chair, if I may ask, so what I'm hearing from you is certainly aspect of flexibility that's, I think, would be welcome. But I'm always conscious on how this will impact the applicants. Can you explain how these changes will be communicated to both clients and Canadians?
Yes, absolutely. The provisions, the amendments contain provisions, for instance, to ensure transparency in the application of the new proposed authority. These include ensuring that the economic goal upon which the minister seeks to conduct an attribute-based round be contained in the ministerial instruction itself, which is posted publicly on the departmental website. Furthermore, to continue with this purpose, not only the goal that was sought, but also how many individuals were invited through the use of these new authorities must be included in the annual report to Parliament on immigration. And in terms of interaction with clients, if I may, each client will set up a profile within Express Entry, and therefore the system is already aware of the attributes that these clients possess. So as is the case currently with the Express Entry system, these candidates are waiting to be invited to apply for permanent residence. And so by the same mechanism that candidates in the pool are informed that they've been invited and have been asked to submit their application for permanent residence, so will be the system under these proposed amendments.
Thank you. And I have very few time, so I'm going to ask, because that's very, very sensitive to me, and you did make remarks about, can this change to the Express Entry contribute to the government's official languages commitment, and if so, how?
Thank you, Chair, for the question. And yes, it can, and if I may explain, so up to date, the Express Entry system has, in fact, been amended to increase the amount of points provided to candidates who are French speakers or bilingual within the system. So to date, the means by which the department is able to recognize and contribute to this goal is through the addition of extra points. Having said that, there are still those...
Sorry for interrupting. Time is up for Ms. Lalonde. So we will proceed to Mr. Trudel for 6 minutes. Mr. Trudel, you can please begin.
Merci, Madame la Présidente.
Thank you, Madam Chair. And I thank the witnesses for having joined us indeed on short notice. It's a very important and very interesting topic, the matter of immigration. Let's talk about Quebec and the selecting permanent residents. That's via selection certificates via the special agreement between Canada and Quebec regarding that goes back to 91, I think 1991. So the changes put forward in C19, will this have any effect on that agreement with Quebec or not at all?
Impact on the selection authority that was granted to Quebec via the Canada-Quebec Accord. Thank you.
Merci.
Thank you. We know that at present, 40,000 files for permanent residency in Quebec are in the system. I understand that changes affecting those not going to Quebec will not help deal with that delay for Quebec. But don't you think that should be dealt with directly in C19?
I thank the chair. I thank the member for the question. In this case, as I can speak to the application management within the express entry system, and here there is the ability to pause the intake of applications, which has been done for federal programs since September 2021. And this allows the department not only to catch up on those inventories of federal economic applications, but in doing so also allows the department to focus more broadly on the treatment of economic class applications writ large. Thank you.
Merci. Bon, parlons d'entrée express.
Thank you. So speaking of express entry, it's often been touted by the federal government as a way to solve the Francophone immigration problem because these cases are processed within 6 months. So how much will the current changes help us meet the Francophone immigration aims?
Thank you, Chair. The department is quite aware and concerned with the service standards within the Express Entry program, which is why intake was paused in September 2021 and is expected to resume in July of 2022. And in so doing, there's a recognition. These amendments themselves, I should add, do not impact treatment of applications or existing or future processing times. However, it's the intent that once application intake within Express Entry is resumed in July, that the service standards we will be able to once again strive to attain the service standards of Express Entry.
Bon. OK. Pour continuer encore sur le même sujet.
All right. Still on the same topic. What will actually change for Francophone immigration, given that the figures for 2022 are still not meeting the goals set by the government? How will C19 change that?
Thank you, Chair, for the question. Express Entry already plays a large role in helping to increase Francophone immigration to official language minority communities outside of Quebec. The changes themselves would permit, for example, the minister to focus on all French-speaking candidates within the Express Entry pool. So currently, while French-speaking candidates are provided with bonus points, which will increase their ranking score, it may not invite all French-speaking candidates within the pool. So theoretically, with the proposed authorities in use, if the minister chose to do so, the department would be able to conduct an invitation round that would virtually invite all of the identified French-speaking candidates within the express entry pool. Thank you.
Merci, merci. Pensez-vous?
Thank you. Do you think that with the budget that has been allocated to express entry that we'll be able to finally meet the 6-month processing goal?
Thank you, Chair, for the question. Of course, resource-wise, funding for such the express entry program is provided through the multi-year immigration levels plan. With respect to returning to service standards, yes, the intent is for those who apply following the resumption of invitation rounds to be able to have their application, once received, a full application, treated within service standards for issuance of a permanent residence visa. And furthermore, it speaks to why the government chose to pause the intake of new applications in September 2021, which was so to catch up on the applications that had accumulated during the pandemic. Thank you.
We will now proceed to Ms. Kwan. Ms. Kwan, you will have 6 minutes. You can please begin.
Thank you very much, Madam Chair, and thank you to the officials for coming to our committee today. I have questions in both areas. So let me first go to the piece around the fees. Just to be clear, under our current rules, the Service Fees Act, for immigration, the SFA requires the government to reimburse portions of fees when service standards are not met. And then there are certain exemptions to which in areas where service standards are not met, the government does not have to be reimbursed and they're exempt. And for Bill C-19, it is now asking for further categories to be exempt for the government to have to reimburse fees if they don't meet service standards. Is that correct?
Yes, Madam Chair. Thank you for the question. I can answer that question. As it stands right now, all these 4 fees fall under the temporary resident category, and all other fees under the temporary resident category are currently not subject to the Service Fees Act. And therefore, we do still provide service standards, and we do still have service standards in place for all these fees that we publish on our website. However, we are not subject to the Service Fees Act, so therefore we do not remit fees when these services standards are not met. So these 4 fees would be added to this list specifically of fees that are currently exempted.
Yeah, so that is to say, if an applicant processing exceeds service standards, then they will not get reimbursed if this passes, right? That's the nub of it. And this
Correct.
is calling for it to be retroactive back to 2017. So that is to say, one could only assume that the government, there are a lot of files to which people's application have not been processed within service standards. And if this is not passed, then the government owe people a lot of money. And you don't want that to happen. Isn't that the gist of this situation?
Thank you for the question, Madam Chair. So in terms of these applications, these 4 types of applications have a relatively low volume compared to our other types of applications, especially in the temporary residence stream. So therefore, it's really a question of establishing the processing times and being out of fairness as well across all our clientele, where some clients would not be entitled to a refund if the services standards are not met, for example, for a temporary resident visa. While for these 4 applications where it's a case of inadmissibility, clients would be entitled to a refund if the services standards are not met. So this is a question of consistency and transparency.
Yeah, well, I'm troubled by this because one would think that the government should meet its service standards. And if they do not meet the service standards, then the application should be reimbursed a part of the fee. And the ask is to say that, no, they don't need to be reimbursed, and so therefore they should be exempt from the requirement of having reimbursed. That troubles me. And this goes retroactive back to 2017. So I just want to put that on the record here. On the second area to which I have questions about, with respect to the express entry categories, so now the bill does not actually stipulate what categories these are, what sort of jobs categories are we talking about. It just kind of gives broad authority to the minister to make that determination. So within the bill, it does not provide for parliamentary oversight as to what these groups will be, and there's no process to whether or not these groups will be fair. Like, how would be fairly chosen, and how would they be selected? So why didn't the officials actually put in a requirement so that the groups that the government are thinking about that they would have to make that list? So exactly who are we thinking about with this provision?
Thank you, Chair, for the question. So within, so first, the economic goal upon which the invitation is conducted will be in the instruction itself. With respect to process, this is something that is currently being developed. Having said that, just for examples, features such as consultation with employer groups and other stakeholders with awareness of labor market information would be a likely reference, as well as mentioned, the objectives within the Immigration Act themselves. Consultation with colleagues at Employment and Social Development Canada who have knowledge of labor market information. And then finally, consultation with provinces and territories could be some of the areas upon which, when in preparing advice as to what category-based rounds could be conducted upon, could be examples. Thank you.
Do the officials have a list of occupations in mind right now?
Ms. Kwan, your time is up.
Can I just get a quick yes/no answer?
Thank you for the question. Currently, there are no specific occupations in mind.
Thank you. We will now proceed to our second round. Mr. Benson and Mr. Ali will have 3 minutes each, and then we will have 1.5 minutes from Mr. Trudel and 1.5 minutes from Ms. Kwan. So we will proceed with Mr. Benson. Mr. Benson, you can please proceed. You will have 3 minutes for your round of
Sorry,
questions.
Madam Chair, I don't mean to interrupt, but very quickly, are we going to have enough time to give instructions to you on how to write the letter?
One second. Ms. Kwan, thank you for your question. So we were asked by the Ministry of Finance to do this study. If we want to propose some changes, then we will write a letter with the amendments to the Ministry of Finance. But if we don't propose any changes, then we don't report back.
Thank you, Madam Chair, for that clarification. I do have some proposed changes. And so given that we have limited time, we have to do this today. I would suggest that we actually go to that discussion now.
Yeah, so then we have to. Okay, so then we will have to stop our round of questioning and talk about that. Okay, Ms. Kwan.
Okay, then on that note, I do have some suggestions on both provisions. On the first provision related to the categories of groups on the express entry procedures, I am troubled by the fact that there is no parliamentary oversight as to what these groups will be, and that there's no process as to whether these groups will be fair or how effective they will be in selecting people who would provide economic contributions to Canada. I know that there's this broad notion that they would have to provide some sort of contribution. We just heard from officials as well that they actually don't know who these groups might be at this point in time, so we have no inkling as to that. So I think it would be very important for us to request FINA to include, by way of an amendment for this provision, for the government to list out the groups that they are intending for this to affect, and also to ensure that there is a transparent process to the selection process to determine who will get on the list of occupations that are needed. Because without a transparent selection process where industries are able to provide formal submissions on which occupations are in need, an objective committee to determine the needs of these occupations, the process could become fodder for lobbying industries. And that's not what we want. So I think we need to have established criteria and a transparent process. So I would like to make that suggestion by way of amendments for FINA to incorporate into this provision. With respect to the second provision, I am troubled.
I just wanted to let the officials know that if they would like to leave, they can leave. On behalf of all the members, I would like to thank all the officials for appearing on such a short notice and for all the work which you do. So if you desire to leave, you can. Thank you. And we will proceed with Ms. Kwan.
Thank you very much, Madam Chair. And on the second provision where it relates to the fee, what we're talking about here is to allow for the government to not reimburse applications under 4 categories: authorization to return to Canada, determination of rehabilitation, restoration of temporary resident status, and temporary resident permit, to not reimburse a portion of the fees if they don't meet service standards, retroactive back to June 22nd, 2017. I think that is wrong. The government set these standards, and they need to meet them. And we already know that there's been exceedingly excessive backlog and processing delays. And now the government's trying to find a backdoor to say, oh, well, even if we have processing delays, we are not going to be responsible for that. And by the way, you're going to still be on the hook for it. I don't think that should be allowed. So I would propose that we instruct FINA to strike this out. They should not be allowed to have zero accountability in processing. And that's what this is, zero accountability in processing delays, and we should not be allowing for that, Madam Chair. So that would be my suggestion for us, for you, Madam Chair, to incorporate into the letter to FINA. If I need to move those changes as a motion, I will.
Is the desire of the committee that, as in my capacity as the chair of this committee, I write a letter back to the chair of the finance committee and incorporate the changes which have been said by Ms. Kwan. Is that the deadline to do that is May 27th? So I will draft the letter and send it to the chair of the finance committee. Thank you. Is it the will of the committee to adjourn the meeting? Yes. The meeting is adjourned. Have a nice...